have a landmark custody decision to tell you about. It involves frozen embryos and who has the right to use them to conceive a child even after a relationship ends. So here's what happened. A state judge ruled a woman can use the embryos created with her ex-boyfriend 4 years ago, even though he says he was told they would both have to agree before anything could happen. And he joins us here this morning, joined by Jacob Shafransky, the ex-boyfriend, and his attorney, Brian Schroeder. First of all, Jacob, how do I say your last name?
It's Shafransky.
All right, good. So I got that right. That's always most important. A little bit of background. You were dating someone. She was about to have treatment for cancer. She was worried because of what doctors had said that she wouldn't be able to conceive after that treatment. So you agreed with her to make some embryos, correct?
The initial discussion between Ms. Dunstan and I was to both make embryos and eggs, kind of to provide us the opportunity to, in the future, to see where the relationship would go and give us the option of, deciding how we'd go about, her desires to potentially become a mother and my desires to potentially assist her in having a child if that were the case. So we did plan on both making eggs and embryos.
Okay, so you signed a document at that time. What did the document say as far as you knew?
Well, the document was fairly clear. When we went to the fertility clinic, our situation was very unique. Our timelines were very small. She immediately needed to undergo her treatment, and of course we were not married and were only dating a few short months. The document stated that because these embryos, any that were to come about, were equal parts, both ours as far as genetic material went, and we weren't a married couple, it was very clear that they stated that at the time of use of the embryos, both parties must consent and give their consent for their use. And that is something that both Ms. Dunstan and I did sign, in fact.
There was also a co-parent agreement that going forward you two agreed to raise a child together. You did not sign that. Why?
I did not sign that. That is correct. After meeting with the fertility specialist at the clinic, we were encouraged to develop any type of ancillary agreements or any further contractual language that would further guide us in how we were to use the embryos if they were to come to use. And we did make declarations of dispositions in the case of my untimely death or Carla's untimely death, and what would to be done with the embryos if we were not in fact to use them. But they encouraged us to, seek legal counsel and to draft a document that would be in support of or kind of supersede their consent forms in which we signed. There was a lot of discussions. We did meet with attorneys, but ultimately no document was signed. And the discussion went back and forth between either co-parenting or being a sperm donor in my case.
Now, obviously, there were some legitimate questions about what the long-term prospects were of this relationship. You say you were motivated by the exigent circumstances. This had to be done right then because she was going through treatment. But if you agreed to make the embryo, didn't you do that kind of understanding that they may be used?
In part I did. We had discussed, and Carla had attested to that, that we would both make embryos and eggs, because even she had reservations on whether or not she wanted me to be involved in any future children that would come about as a result of this. And she felt, and I agreed, that both eggs and embryos would be a good decision, where if she did not want me to be involved, there would be the eggs that she could choose to use on her own without any consent or involvement of myself.
So
this was something that would provide us that opportunity to make that decision down the road. And unfortunately, when the egg harvesting was completed, the number of eggs that the physicians expected to get was virtually half. And they made the recommendation to create all embryos. And in my understanding of my documents, and as far as my rights, it was very clear to me that my consent would be needed for use of any embryos that I was genetically responsible for.
So the judge says,
I don't feel. Oh,
the judge says,
go right ahead.
Because I'm going to lead you into your next point. The judge then takes a look at it and says, okay, I get it that you had some rights here and she had some rights, but I believe her rights outweigh yours because the right to have the child is bigger than your right to consent to that, because she doesn't want anything from you. She says she wants no support. She doesn't want your involvement. That's not good enough for you. Why?
Just to say that you don't want money or supportive services in having a child, I think is kind of dismissive to the grand implications of everything. Neither Carla or I had ever been married, nor did we have, children up until that point. And this was something that, we needed to give consideration to down the road. To say that just because somebody doesn't want money for me, they should be able to, force my hand and bring children into this world against my will, time has passed. I've unfortunately had to deal with a lot of, personal confliction on this matter. I have, had some deep implications as far as my relationships go with other people, and given the time to really consider this, which is what creating the embryos allowed us to, and thinking about this, I don't want to be forced into having a child, especially when I'm not ready for that in my life. It's something that transcends money. To reduce it to financial support, I think, is insulting to both Ms. Dunstan and I.
And that the idea for you is that this is going to be your child. It's half yours. It's going to come into the world, and that wasn't a decision you were allowed to be a part of, and it's fundamentally wrong. So what did the judge get wrong?
The judge, I believe, in my understanding, felt that there was a verbal agreement that was reached that superseded any type of written agreement in which we signed, which I think is not necessarily accurate. To say that I was asked to create embryos, absolutely. To say that we discussed issues of consent, we did not, and Ms. Dunstan attested to that also. And secondly, we were planning on making both eggs and embryos, allowing us an out, an option to separate if need be, where she could make a decision about her reproductive autonomy without me. And when it came to the two of us potentially making that decision together, I think we both have an equal say. I'm not asking anything from the courts that, I wouldn't feel Carla should have in the equal decision. And that's really what this is about. We both have equal rights, and our consent is equal. So how can you forcibly make somebody do something against their will?
Well, that's the interesting question, especially when that person is the man. You're dealing with a culture where the rights have usually been construed in favor of the woman. We have the famous actor Jason Patrick had a similar situation, some different circumstances, but the same issue came up about the rights of the father in a situation where birth is found this way through this type of embryo making. So we're going to follow this case as it goes forward. Jacob Safransky, thank you very much for being here. Brian Schroeder, you were quiet on this because we weren't arguing about the legalities. But as the case moves forward, please keep us in the loop on it. We want to see how this turns out. Big implications for you and for a lot of couples out there. So thank you.
We certainly will. Thank you very much.
All right, Kate.